So, if a will alone doesn't prevent probate, reduce aggravation, and keep a judge out of your family affairs, then what does? Keep watching to find out. Hi, I'm Gary DeWitt. I'm an attorney that practices mainly in the areas of estate planning and probate here in Northwest Arkansas. Sit back, turn off your distractions, and take notes. Let's review a few things before continuing. Your estate, for the purposes of planning, is everything you own, either individually or with others. It is all your property. Estate planning is arranging for protecting your estate during your lifetime, protection of your legal rights during your lifetime, protecting your financial rights during your lifetime, making sure somebody you know and trust is there to make financial, legal, and healthcare decisions if you can't, and the distribution of your final estate. As you can tell, estate planning is as much about protecting you during your lifetime as it is about distributing your final estate. A will is a document in which the person writing the will, the testator, expresses their wishes on how their property is to be distributed. A will really does just a few things: leaves instructions on who receives what, nominates a personal representative to oversee the process and distribute the assets, and nominates guardians for minor children. A will alone requires probate. And finally, probate is the formal, expensive, time-consuming, legal process of admitting the will, approving the will, paying debts and expenses, then distributing what, if anything, is left. During probate, a judge oversees every step. Probate in Arkansas is going to take 8 months or more, and probate is public. If wills by themselves don't prevent probate, then how do you prevent probate? One common tool used to prevent probate is the revocable living trust. The trust is created by the grantor. Grantor means they granted property to the trust. The grantor gives the property they own to the trustee. The trustee is the person who has legal ownership of the property in the trust. The trustee manages the property for the benefit of another person, the beneficiary. Essentially, a trust is a contract between two people, the trustor and trustee, for the benefit of a third person, the beneficiary. A living trust is created during your lifetime. A testamentary trust is created in a will. The most common type of trust used in estate planning is the revocable living trust. Revocable means that it can be changed during your lifetime. Living means you set it up now. With the trust, you are usually the trustor, trustee, and beneficiary during your lifetime. However, if you should become incapable of managing the trust property, you name somebody else to step in and manage the trust property, your successor trustee. The trust owns your property, and you control the trust completely. Therefore, you control the property. When you pass, the trust usually becomes irrevocable, and its instructions are carried out by the trustee you name without probate. The advantages of a trust is the trust property is managed during your lifetime if you become incapacitated, and probate is avoided for all property in the trust. Trusts in Arkansas are not required to pay your final expenses, which can save your heirs literally hundreds of thousands of dollars in final medical bills. Trusts give what you want to who you want in the amounts you want when you want under the rules you create. Trusts provide some lifetime protection without a judge's oversight. Trusts usually have a backup trustee to manage the assets in the trust. But that trustee can only manage trust assets, not your other affairs or healthcare matters. The best benefit of all is that trusts don't require probate. This picture can help you understand what a trust is better. A trust is really nothing more than a contract between a grantor and trustee for the benefit of a third person, the beneficiary. The grantor transfers assets to the trustee. The trustee manages the assets for the benefit of the beneficiary. The most common trust to prevent probate and manage assets is the revocable living trust. With that trust, while you are capable, you are the grantor, trustee, and beneficiary. The trust or trustee owns the property and you control the trust. Therefore, you control the property in the trust. A trust gives you the ability to decide who gets what, when, and how. For example, you can pay out the money in the trust at ages 30, 35, and 40, but pay for college. You can pay for rent, utilities, and food for a child with an addiction. Trusts give you the best chance of avoiding all probate and leaving property to your children without having to pay final medical expenses or worry about other debts. In most cases, the real estate and all personal belongings are transferred to the trust along with the bank accounts and investment accounts. There are several other methods that prevent probate too, but in the short amount of time I have with you today, I just can't list or explain all of them. And all of them work hand in hand with a revocable trust. Thank you for watching today.